everyone, I am with the lecture 2 of the series which we started on law of evidence. As I said, this would be a series comprising of around 15 to 18 lectures at max, and we will be completing law of evidence from point of view of mains examination as well. This lecture would include a discussion upon section 6 to section 8. Moving on to the next slide. As I said in the starting of the series itself that we will be discussing previous year questions as well. In the last lecture, I was not able to include the questions related to that topic which we discussed. So here are the questions which of the topics which we have dealt in the last lecture. All admissible evidence is relevant, but all relevant evidence is not necessarily admissible. Comment. This question is basically related to relevancy and admissibility difference, which we discussed in the table, and for this and for these 2-3 questions, the table is the suffice answer. It is sufficient for any answer related to relevancy and admissibility. Relevancy and admissibility are neither synonymous nor is one included in the other. Elucidate this statement. What do you understand by relevancy of facts? Are all the relevant facts admissible in court? Explain. So all these questions, same, the table would be sufficient. Write exhaustive but brief note on direct and circumstantial evidence. Write a note on circumstantial evidence. Distinguish between direct and circumstantial evidence. Can a person be convicted on circumstantial evidence? We discussed about the circumstantial evidence, what it is, and whether circumstantial evidence is irrelevant, what are the circumstances which can be said to be irrelevant. All this we have discussed with the punch shield case, the punch shield doctrine, which we discussed in the case of, please tell me the case which we discussed in the last lecture. And moving on to the last one of the parts which we discussed was regarding the interpretation clause. So interpretation clause may be discussed about what is fact in issue, what is relevant fact, what is proved, disproved, not proved. We discussed about what is quote. That question I think I included it somewhere, but I missed it. So basically it was what do you mean by quote, and you had to actually explain it with the relevant case laws. What is fact in issue, whether it is relevant fact, explain the circumstances, when can a party to the proceed, when can a fact becomes irrelevant, then explain the meaning of proved, not proved, and disproved. So this was regarding the last lecture, the questions related to the last lecture. Moving on with today's lecture, we will be discussing, as I said, on section 6, 7 and 8. So first of all, let's understand what kind of questions are being asked. Comparatively examine the doctrine of res gestae with the provisions of Indian Evidence Act, section 6. Define motive, how far motive, preparation and conduct of a party are relevant, section 8. What is relevant fact? Explain. A victim of rape, while coming back to the village, was beating and abusing the accused. State what part is relevant and in what form. So this question includes two sections. Three. One is section 3, that is the interpretation clause. Other is section 5, which deals with what facts are relevant, and section 8, which deals with the conduct of the party, as well as there are certain statements which are relevant under section 8. So we'll be discussing with the section 8, and this question you need to answer in light of that section. Explain the doctrine of res gestae, again section 6. So this is how we'll continue with our lectures. We'll first discuss the important questions which were asked from that topic previously, and then how we need to focus upon and how we need to write answers regarding that topic. Moving on and starting with our today's lecture. So here, starting with today's lecture, relevancy of facts forming part of same transaction. Section 6, facts which though not in issue, facts are not in issue, are so connected with fact in issue as to form part of the same transaction are relevant, whether they occurred at same time and place or at different times and places. All these words which I have highlighted in this section are important from pre-point of view. First of all, section number is important. Section 6 deals with res gestae or the facts which form part of the same transaction. Res gestae is the term, it is a Latin term, and it is a doctrine which is followed under English law. Under Indian law, we term it as facts forming part of same transaction. These facts were not in issue. They are actually related to the fact in issue. What is fact in issue? Interpretation clause section 3. So they are related to fact in issue and they are relevant because of this relation. It is another thing which is important from pre-point of view, that it may have occurred at same time or at different times. While reading the section, we forget this part, at different times. So focus on the section first. That is the key to your success in preliminary examination. Moving on with the illustration. See, I have discussed certain illustrations which are related to the Bare Act, because as I said, Bare Act is the key for any preliminary examination. For cracking it, it is the key. So you need to know your Bare Act by heart, and that will help you in your mains as well. A is accused of murder of B by beating him. Whatever was said or done by A or by the bystanders at the beating, or so shortly before or after it as to form part of same transaction, part of the transaction, is a relevant fact. Then A is accused of waging war against the government of India by taking part in an armed insurrection in which property is destroyed, troops are attacked, goals are broken open. The occurrence of these facts is relevant as to form part of the general transaction, though A may not have been present at all of them. So, A को पता भी नहीं होगा कि उसने पार्ट लिया और कहीं पे उसका इफेक्ट कुछ और हो रहा है. जैसे यहाँ पे हो सकता है कि ये जो ट्रांजैक्शन था उसमें ए का जो इन्वॉल्वमेंट था वो सिर्फ था कि मुझे प्रॉपर्टी डिस्ट्रॉय करनी है, because I am waging war against government of India. There is a conspiracy that I'll take part. There is this armed insurrection. So it basically is a group of people who are waging war against the government of India, and they are basically destroying property of the government. They are breaking laws. So A was there. He was destroying property of the government. He didn't know what all other things were planned in this waging war, what all other destruction took place. But he shall be held liable, he shall be held guilty under this section, because all these facts are relevant as they form part of the general transaction. Now, what is the general transaction over here? It is the waging of war against the government of India. English doctrine of res gestae, things done in the course of same transaction. That is what literally this doctrine implies. Indian context में it also includes things said and done in the course of transaction. So here what is relevant is things said also becomes an important aspect, a relevant fact under Indian law. Now we'll understand how, or we'll interpret same transaction. As we all know, Indian Evidence Act, or even if you don't know, it is a new fact to you. It is important to keep in mind that Indian Evidence Act was designed, it was actually framed by Stephen. So this person is important. What he said about same transaction was that efficient test of whether a fact forms a part of same transaction is such fact is related to another in. These 3 points are important for understanding whether a particular fact is related to the other fact or not, or whether it can be termed as a part of the same transaction or not. Two facts, or the fact which we are considering is related to fact in issue with point of purpose, or one is the cause, other is the effect, or they are the probable and the subsidiary acts of the fact in issue. This was the test which was given by Stephen, that if any fact is related to another fact in issue, in any of these three modes, it would be considered as part of the same transaction. So after discussing the efficient test which has been given by Stephen regarding whether a fact can form part of the same transaction or not, we'll move on to the elaboration of which kind of facts can form part of the same transaction. So there are two facts. One is the physical act, other is the words which are accompanying such acts. We'll move one by one. First we'll discuss about the physical act or omission, then we'll move on to the words accompanying such acts. Physical act, two acts are said to be connected to one another if they are connected together by proximity of time, proximity of place, continuity of action, or community of purpose. This is basically the same thing or the same test which was given by Stephen, with certain changes like time and place is also being included into it. R versus Foster is the first leading case on this point of physical act or omission. Here what came into issue was whether the statement of a bystander who didn't saw a car coming and hitting the victim, but he saw the victim getting unconscious or being hurt. So whether such a fact is a fact forming part of the same transaction. There was the car accident in which victim was hurt. Victim got hurt. It was hit by the car. He was hit by the car. The bystander went to the victim and the victim told him that I was hit by this car. So this was being considered, it was being taken into consideration before the court that whether the testimony of the bystander would be considered as a part of the same transaction. It was held that such statement which was made by the bystander is relevant as it forms part of res gestae. Then these are the two cases, R.M. Malkani versus State of Maharashtra and Yusuf Ali versus State of Maharashtra. These are basically related to the tape recorded conversation, in which it was held that a contemporaneous tape record is a relevant fact and is admissible as res gestae under section 6. Under Yusuf Ali case, in this case, the Supreme Court actually held what are the requirements and when can a tape recorded conversation can be held to be admissible. There are three things. First, the conversation must be relevant to matter in issue. Second, there must be identification of voice, that there is no tampering with the recording. And third, there is accuracy of the tape recorded conversation. So these facts, these cases, they basically highlight that a physical fact or omission, they form a part of the same transaction. Moving on to the second part, that is the words accompanying such acts. See, because of these words only, we haven't used res gestae in our legislation. What we have used is facts forming part of same transaction. So facts include all the things, the physical fact as well as what is being taught or what is being spoken. So words accompanying such acts. Such words must be spoken by the person doing, person to whom the act was done, or any other person or persons who are present there at that particular point of time. Such words must be contemporaneous and spontaneous. No time period must be given, no time lapse must be there, no time interval must be there, so as to provide opportunity for fabrication. There was a case, this is a famous case, Thompson versus Trevanian, in which wife was being assaulted by husband, and as soon as she got hurt, and immediately on receiving the hurt, she actually called on to the police helpline, and this whole transaction was considered as relevant as it was forming part of the same transaction. It was held important under the doctrine of res gestae because there was no time lapse which was given for invention of a false tale. So such evidence, only such evidence in which time period is given and there is a probability that a false tale can be invented in that time phase, that would be inadmissible. This was there was a case of R versus Bedingfield in which the accused cut the throat of the victim. Victim, she came out running from the room and she told her aunt, see what Bedingfield has done to me. Court held that there was a time phrase which was given to that, which the victim actually took before stating this statement. So this such statement was held to be inadmissible under the doctrine of res gestae. R versus Christie. This was the case of indecent assault in which a victim was a minor and he told about the assault, which was actually a sexual assault which was being done upon him, which was committed upon him by one of his I think one of his teachers, but it was considered as something, and he told about this assault after a period of time, after a lapse of time. Now this statement was also held to be inadmissible because it was not spontaneous with the transaction in issue. There was a time period which was involved, hence it was held not to be relevant under the section, under res gestae, under the doctrine of res gestae. Under Indian law, there is a case, most important case, Krishna Kumar Malik versus State of Bombay, in which it was held that a statement can form a part of transaction or part of the same transaction only if it is spontaneous and contemporaneous. If it is given after a time period or after a certain time interval, it would become hearsay and it would be held as not admissible. Moving on to the next slide. This is important. See, the general rule is that hearsay is not admissible, but res gestae or the facts forming part of same transaction, there actually is an exception to this general rule, wherein any statement which is made by the bystander as well, who has not, like this was a case of R versus Foster, in which the bystander statement was that I saw the victim getting hurt, but he didn't saw the speeding car coming over there. This statement was held relevant, and this is something which is against the general rule, that is hearsay, because he didn't see the car coming. But since it forms a chain in the transaction, hence it is held relevant under the doctrine of res gestae, or under Indian law we can say under section 6. Hearsay is the evidence which is given by the person who has not seen, heard or experienced the facts which he is stating or which he is testifying. Facts which are occasion, cause and effect of fact and issue. Section 7 deals with such facts which are basically occasion, which help other facts to take place, which are the cause, the reason why the fact and issue actually happened, and the effect of fact and issue, that is what was the result of fact and issue. Like for example, if a person was murdered, so there were imprints of the shoes of the murderer or of the accused. So in that case, the effect of the murder was, this would be considered as the effect of fact and issue. Section 7, facts which are occasion, cause or effect, immediate or otherwise of relevant facts or fact and issue, or which constitute the state of things under which they happened or which afforded an opportunity for their occurrence or transaction, are relevant. Now the question was whether A robbed B. The facts that shortly before robbery B went to a fair with money in his possession, and that he showed it or mentioned the fact that he had this money to third persons, are relevant. Now how this is relevant? Because it is providing an opportunity for the robber or for the thief to commit the theft. See? Occasion. The first point is occasion is relevant if it occasions the fact and issue, the sets of circumstances which are responsible for happening of the principal fact, that is occasion. The cases of R versus Richardson, I'll first discuss the facts of this case. In this case, what happened was that a girl was murdered. The girl was pregnant by the accused, and the facts of this case would slowly help you in understanding all these factors which are mentioned in section 7. R versus Richardson का केस जिसमें बोला girl alone in cottage at the time of murder, so it provided an opportunity and the occasion as well, the occasion that there is nobody else present and the committing of murder of such a person is possible. So that girl was alone in the cottage at the time of the murder, cause the set of circumstances which actually explain why the particular act was done. So here R versus Richardson, in this the fact that deceased girl was pregnant by illicit relation with the accused. So accused wanted to get rid of the girl as well as of the pregnancy. That is the reason he committed the murder. Effect: facts throwing light upon happening of the event and the nature of the act. So in this case, the footprint showed sole of the shoes of the murderer which were newly mended. Now this was something which was the effect of the fact in issue. The fact in issue was whether the girl was murdered by this person Richardson or not. Opportunity. The question is, now that this is one of the illustrations of section itself. The question is whether A poisoned B. The state of B's health before the symptoms ascribed to the poison and the habits of B are known to A, which afforded an opportunity for administration of poison are relevant facts. State of things, facts under which the principal fact happened and the facts in background of which the principal facts happened. If those facts actually facilitated the happening of the principal fact or the fact in issue, they would be considered as relevant. Moving on to the last section of this lecture, section 8. One of the important sections for preliminary as well as mains examination. The illustrations of this section are also very important. Some of the illustrations from which questions can be asked and there is a probability that they shall be asked because they actually provide an understanding about this section and they have been asked in earlier preliminary examinations as well. Starting with the section, any fact is relevant which shows or constitutes motive or preparation for any fact in issue or relevant fact. So here what we are concerned with under section 8 is motive, preparation, previous or subsequent conduct. Three things: motive, preparation and conduct. We'll start with this. There are two explanations which are annexed to this section, which we will deal with the illustrations mentioned in the section after learning about these three factors about motive, preparation and conduct. Motive is basically the inducement for doing an act. It is the evidence of the motive which actually helps the accused to connect with the deed, and its absence actually weighs in favor of the accused. There's this leading case of Munish Mubar versus State of Haryana 2013, in which motive was held to be an important aspect in case of a relevant fact in case of a circumstantial evidence, because motive actually highlights the guilt of the accused, the evidence indicating the guilt of the act which was committed, that he is untrustworthy or unreliable most often, because it is only the perpetrator of the crime who has the knowledge of the actual circumstances under which he committed the crime. He is actually aware of the motive behind committing an act. So if evidence on record actually suggests those circumstances, they would be considered as a relevant factor, as a relevant fact under section 8. Moving on with the illustration, A is tried for murder of B. The fact that A had murdered C and that B had tried to extort money from A by threatening to make his knowledge public are relevant. Now here the fact was that person B was murdered and he was murdered by accused A. Trial was going on and during the facts it was revealed that B actually knew about the previous murder which was committed by A. So that is the reason, and he tried to extort money from A for that knowledge, or otherwise he would have made it public or he would have complained against A. So the reason why he committed murder of B was that to hide the fact that B knew about the murder which he actually earlier committed. Preparation. A is tried for murder of B by poison. The fact that before the death of B, A procured poison similar to that which was administered to B is relevant. So preparation of any crime is a relevant fact. That is very logical. Conduct. Now conduct includes everything, the previous as well as the subsequent conduct of both the parties, the accused, the victim, or any agent of any party. All such conducts are relevant under section 8. It includes previous and subsequent conduct. It includes the conduct of the person who is accused of an offense, provided such conduct actually influences or is influenced by any fact and issue or relevant fact. Now this is an important aspect, that only such conduct which actually influences his act, the fact and issue, is a relevant fact. Any party or agent of any party to suit or proceeding, provided such conduct, same thing, it is influences or is influenced by any fact and issue or relevant fact. A is accused, just give me a second. Now see, this is an illustration which is basically explaining about the conduct of an accused. So A is accused of the crime. The facts that either before or after the time or after the alleged crime, A provided evidence which would tend to give the facts of the case on appearance to be favorable to himself, or that he destroyed or concealed evidence. Now when a person would do all such things, whenever he is actually guilty, whenever he has done something wrong, he'll try to hide it. Similar thing here, the illustration is actually trying to highlight that such conduct would be considered as relevant under section 8. Now the explanations, these explanations are very important. Explanation 1, the word conduct in this section does not include statements. It does not include statements. Mere statements it does not include, unless those statements accompany and explain the acts other than the statements. But this explanation is not to affect the relevancy of these statements under any other section of this act. So basically, statements are relevant under some section which we will further discuss in the upcoming lectures. But under section 8, only those statements would be considered as irrelevant which actually explains the conduct, which state something other than the statement itself. We'll try to understand this from an point from this illustration. The question is whether A was ravished. The facts that shortly after the alleged rape she made a complaint relating to the crime, the circumstances under which and the terms in which the complaint was made are relevant. The fact that without making a complaint she said that she had been ravished is not conduct under this section, though it may be relevant as dying declaration under section 32 or as a corroborative evidence under section 157. So this is an illustration which has been annexed to the section itself. Very important illustration. See, in the first part of the illustration, what A did was, since she is the victim, so her conduct is also relevant. Now, along with their conduct, there are certain statements, and the question is whether those statements are relevant or not. What happened to A? The question is that whether A was ravished. Now, the facts that after the alleged rape she made a complaint. So this is basically a statement which is made by her, but it is not a mere statement. It is something which she actually did after being ravished. She made a complaint relating to the crime, the circumstances under which and the terms in which the complaint was made are relevant. Why they are relevant? Because not the mere complaint. What the statements are highlighting is about the fact and issue, and she has actually opted a proper way of making that statement, which has a value, which is not a mere statement. It is actually explaining the act other than the statement. The statement is a complaint, yeah, and here the act is that she was ravished. Now the statement, that is the complaint, is actually mentioning that she was ravished by some person or alleged rape actually took place. So that is the reason why this part or this complaint becomes relevant, because it is not a mere statement. In the second part, she did not make a formal complaint, no actual complaint she made um, after the alleged rape, which she only said that she had been ravished. Now this is a mere statement, no further act, or no, it does not explain any other act rather than the statement. That is the reason it can be held relevant as a dying declaration under section 32, or as a corroborative evidence under section 157. Corroborative evidence and dying declaration we'll discuss in the further lectures, but here what we need to understand is that mere statements are not relevant. Any statement which actually explain the act other than the statement, only such statements would be held relevant under explanation 1 of section 8. Explanation 2, when the conduct of any person is irrelevant, any statement made to him or in his presence and hearing which affects such conduct is relevant. So any such statement which is affecting the conduct of any person whose conduct is actually relevant under section 8, it shall be relevant. So two kinds of statements are relevant. Under explanation 1, only such statements which actually explain the act other than the statements are relevant, and under explanation 2, those statements which are affecting the conduct of the person whose conduct is relevant under section 8 are relevant. So these two kinds of statements are relevant under section 8. The question is whether A robbed B. The facts that after B was robbed, C said in A's presence the police are coming to look for the man who robbed B, and that immediately afterwards A ran away are relevant. So this was the example which was related to explanation 2. The statement was made in presence of the person whose conduct is relevant under section 8. So here, after hearing that statement, the accused ran away. That is the reason why this statement is also becomes relevant. So this was all regarding section 6, 7 and 8, and it is sufficient from point of view of the mains answer writing regarding any of the sections which we have discussed, as well as from preliminary point of view. One thing which we need to remember is that for preliminary examination, Bare Act is the key. You should remember the Bare Act, the important terms, especially those portions of the Bare Act which bear provision which I am highlighting over here, because these are very minor things which we actually while reading or while going through we can miss it. So whenever you read the Bare Act, have this habit of highlighting the important provisions or highlighting the important or the key words of the provisions. That's all. We'll meet next time with the lectures upon section 9 and section 10, 11. So thank you.